I'd like to call the Committee of Commerce and Labor to order. Clerk, if you'd call the roll.
You have a quorum, Mr. Chair.
Thank you. Before we get started, I'd like to recognize our committee clerks, Chad Starzer and Catherine Dent. If you all would raise your hands so we're familiar with you all. And so the audience is familiar with us. And our staff, our lead attorney, she's new to the General Assembly, at least new to us, Chrissy Noonan, and I've had an opportunity to work with her for the last 6 months, and she's just a wonderful addition to the Commerce and Labor team. And of course, the backup attorney who's been backing up this committee for a long time, Frank Munyon. Frank, it's good to have you back again this year also. So, 1699, huh? Yeah, he's on his 400th year here and put the entire title section together for Commerce and Labor. So we do appreciate having Frank back with us too also. I'll get started. We have a little bit of administrative work to do. The Finance Committee has asked for Senate Bill 999 and Senate Bill 1317, who should not have been referred here, to be re-referred to the Committee on Finance. Is there a motion? Been moved and seconded that those bills be referred to Committee of Finance. All in favor, vote. Say, or vote. Yeah. Push a button. Okay.
10 ayes, 0 nays.
Okay. Those are re-referred. I'm going to have my bill 1389 stricken from the docket. We have Senate Bill 1393. That was to be referred to. Yeah, which one? Committee on Finance, yes. Okay. Is there a motion on that bill? Been moved and seconded that 1393 be referred to Committee on Finance. All those in favor, vote on the voting machine.
Nine ayes, 0 nays.
Okay, 9 ayes, and that bill is re-referred. And we have Senate Bill 1457, Senator Vogel's bill. I have a message from the Chairman of the Committee of Courts that be referred to Committee on Courts. Is there a motion to so do so? Been moved and seconded with one complaint to my left, that bill be referred to the Committee on Courts. Clerk, open the rolls.
Ten ayes, 0 nays.
Okay, that bill is out of here. All right, I have a note, and I know there's a number of people here in the audience that wish to be heard on that, but I have a note on from the Chairman of the Committee on Finance that he wants the workman's comp bills that refer to public employees be referred to the Committee on Finance to get an idea of how much it costs. I think we've consistently voted in favor of these on the committee. And reported them out, but apparently the fiscal impact needs to be looked at a little bit stronger. So I have the following bills: Senate Bill 1022, 1030, 1172, 1465, and 1528 to be referred to the Committee on Finance. We can hear the bills in Finance, Mr. Chairman, so I don't want to presume that we're not going to hear you. But we won't take a vote. The only vote we'll take is Committee on Finance, so your testimony would be a lot more apropos in front of the Committee on Finance, and a lot of the members on this committee are on the Committee on Finance to begin with. So we will take testimony in the Committee of Finance. Is there a motion to refer those bills to the Committee on Finance? Been moved and seconded that those bills be referred to the Committee on Finance. Clerk, open the rolls.
Mr. Chairman.
Senator Cosgrove.
Thank you, Mr. Chairman. I understand where this is going, but we have so many people that have come up today to express their concerns about this. Can we at least acknowledge who's here to speak to it?
Certainly, Senator Cosgrove. If you came up to here to testify today, if you would please stand up on these bills. Okay, that's a good-sized audience. Yeah, we might, given the size of the crowd, if there is a few spokesmen, John, are there a few spokesmen that we want to hear from? Let's go ahead and do it, because we have trimmed down the docket significantly. We certainly have a little bit of time, and there are a number of members of the Committee on Finance here.
I appreciate that.
John, would you like to coordinate that?
Yes, I'd be glad to.
Go ahead.
Again, as the chairman mentioned, we have a lot of people here. If we can just have maybe 3 or 4 people come up, identify yourselves and who you're speaking for, that would be of great benefit to the committee.
Oh, okay. John, if I could interrupt you real quick. Senator Sproul has a bill. He needs to be heard.
Please.
I'm sorry, I take it out of order. It's a courtesy to a member. Okay. Senate Bill 1079. We'll give it in a minute.
Thank you, Mr. Chairman. Senate Bill 1079. Mr. Chairman and members, Senate Bill 1079 is a minimum wage exemption, eliminate the exemption to Virginia minimum wage requirements for newspaper boys, shoe shine boys, babysitters, and etc. These bills remove the exemption to Virginia minimum wage law. The exemptions are clearly rooted in Virginia history of discrimination against African American workers who were concentrated in lower wage service type industrial for jobs. The Virginia Minimum Wage Act covers workers not already covered by the federal minimum wage law. There is no reason for the workers in these professions to be paid below the minimum wage. It is time to end these Jim Crow legacies. We're talking about ushers, babysitters, shoe shine boys, newspaper boys, who work at least 10 hours a day, who not make at least a minimum wage.
Okay. It also eliminates, I notice, it eliminates the measure for those people that employ 4 people or less.
That's right.
Do you know the rationale for that?
No, sir.
Okay.
Mr. Chairman.
Senator Norman.
Senator Sproul, this may not have been something you've contemplated. I never underestimate the creativity of some business persons. With that exemption of 4, could somebody form a series of subsidiary LLCs or companies to try to circumvent it?
I can't hear you, Senator. I'm sorry.
I think what Senator Norman was asking is that with the exemption of 4 employees or less, is a potential for unscrupulous employer to set up 4 or 5 LLCs and employ 3 people per LLC and effectively have 15-person work group.
Sounds, I hope not. That's not the intent. Like I said, it could be, but I certainly hope not.
Okay. Is there any other questions for the patron? Is there anyone here that wishes to speak in favor of the bill? You have a few, Senator Sproul, if you could give them a chance. Ms. Bobo, good to see you.
Hey, thank you. I'm Kim Bobo, Director of the Virginia Interfaith Center for Public Policy. We support this. The removal of these historic Jim Crow language in the bill is really putting us in the current century. Going from 4 to 1 workers covered by the minimum wage basically allows a business with 2 or 3 employees to not be put at a competitive disadvantage for those who happen to have 4 workers. It is also how 32 other states do it. So again, these are common sense proposals that I think update our current minimum wage law. Thank you.
Thank you.
My name is Robert Field. I'm with the Virginia Department of Labor and Industry, and the governor supports 1079.
Thank you.
Thank you.
Good afternoon, Julia Newton with SEIU, and SEIU supports this bill.
Thank you,
To
Julia.
remove the exemptions. Thank you.
Thank you, Julia.
Good afternoon. I'm Megan Healy, Chief Workforce Development Advisor for the Governor, and we support this bill.
Thank you.
Good afternoon. My name is Thomas Bowman with the Laborers Union of North America. We support this bill.
Thank you. All right. Is there anyone in opposition to the bill?
Mr. Chairman, members of the committee, Nicole Raleigh with NFIB, representing about 6,600 small business owners. Our main concern with the bill, frankly, at this point is that it is written to the Virginia Minimum Wage Act, and certainly would be concerned if this ever became a vehicle at some point in the process for raising Virginia's minimum wage. Thank you.
Senator Sasslaw.
Out of curiosity, what do you think somebody who works shoeshine boy should be paid? Or shoeshine man or what? What do you think? Tell me.
Well, I don't know. I don't work in that industry, and so I wouldn't know.
But you're opposed to them making more than $7.25 an hour, obviously.
My main
Or even
concern.
making $7.25 an hour.
Well, I have no idea what their rate is. It could also be that it's a tipped industry. So a lot of times industries that have tipping involved are exempt. So I'm not sure if that was for part of that reason why.
Well, let me, Mr. Chairman,
Yes.
let me just
Senator
give you an
Sasslaw.
example. One of the more controversial ones that are below that is what's called the tip minimum wage. Now, the people who are under that don't want it raised because most of them earn $25 an hour. And the tip minimum wage in Virginia is $2.50. If they don't earn enough to get that for the hours they work to get it to $7.50, the employer has to make up the difference. If I listen to you, the employer shouldn't have to do that.
I'm not addressing the actual issue of whether or not they should be exempt. What I've mentioned, our main concern is the fact that this is written to Virginia's Minimum Wage Act in general. And so there could be amendments later down the road.
But
So
they don't even-
I'm just saying that that's our main concern.
But
I
they
mean,
don't even
that's
get the
something you
minimum
can or
wage.
can't
We
do.
only have one bill before us right now as you stand there. And you don't think those people should make the minimum wage. You think they should be paid a lot less.
I've never said, that's not what I have said. I have said that my only concern is what this could become down the road.
What could it
Senator
become?
Sasslaw, let me
Mr.
get a handle
Chairman.
around this, okay?
What could it become?
There could be an amendment that deals with raising Virginia's minimum wage, which that we have opposed. And that's the only concern that I have with this bill. That's all I'm saying.
Okay, does that complete the questions?
Yeah.
Okay. Senator Sproul, I think we know.
I got a question.
Oh,
I have a
Senator
question for
Norman.
Nicole.
Nicole.
Nicole, under the proposal of this bill, does it in any way constrain or prohibit an employer from paying more than the minimum wage if they want to and the employee so deserves it?
No, it does not.
Thank you.
Okay.
Which is why.
I believe there's some other
why we
folks that
just
wish to
paid
speak.
the lowest they can get away with.
When's the last time you got your shoes shined in the airport?
Mr. Chairman, members of the committee,
I
Jody
tip.
Roth on behalf of Virginia Retail Federation, and we also oppose this legislation based on the same premise Ms. Nicole Riley just mentioned, that it is tied to the Minimum Wage Act.
Thanks,
Thank you.
Jody. Thank you. There's a few others, Senator Sproul.
Mr. Chairman, members of the committee, my name is Robert Melvin, and I'm here with the Virginia Restaurant, Lodging, and Travel Association. And for the reasons that have been previously mentioned, we are in opposition to the bill as well.
Thank you. Any others in opposition? Okay, Senator Sproul, briefly.
Mr. Chairman, I'm not worrying about paying over. My concern right now that if we can get them up to the minimum wage, that's the problem. Because the sous shine boards and those, et cetera, they can get anything less than that. My concern, if I can get them up to the minimum wage, I'd be satisfied with that. That's the main goal of this bill.
All right, thank you, appreciate it. Okay, any discussion in the committee? Committee operates by motion. Been moved and seconded that Senate Bill 1079 be reported.
Yeah.
Clerk, open the rolls.
Press yea for me. Press me for me. Okay, yeah. Oh.
7 ayes, 6 nays.
7 ayes, 6 nays. That bill's reported. Thank you, Senator Sproul.
Mr. Chairman, if there are no Democrat, I have to give my process. If there are no Democrat left, could I, if one's not here when I leave, I want to know, can Senator Collins go be a Democrat to take the rest of my bills?
I think Senator Norman's more of a Democrat than Senator Cosgrove. But you pick your Democrat, okay? All right. Senator
High praise
Cosgrove,
indeed, Mr. Chairman. I appreciate it.
even though we know these bills are going to be referred, we do want to hear from a few of the speakers that made the trip up here.
Thank
So
you, Mr. Chairman. I will be very brief as well. This bill adds colon cancer, brain cancer, and testicular cancer to those presumed to be caused by certain line of duty employment. So that being said, we all know it's going to go to finance, where I'm sure that it's going to get the most marvelous of attention. But let's please hear from just a few folks that are here to speak.
Absolutely. Thank you, sir. Your name and who you're with.
Thank you, sir. My name is John Wright. I'm president of the Frederick County Professional Firefighters Association in Winchester, Virginia. Rise in support of the bill. Appreciate the opportunity to speak real quick. If you don't know, cancer is the #1 killer of firefighters in the United States. It surpasses heart attacks at #2 and sadly suicide at #3. We've been working for numerous years trying to fix our broken Workers' Compensation Act dealing with cancer presumption. Specifically, the bill would add numerous cancers, 3 additional cancers, the cancers of the colon, brain, and testes to the list of cancers that are presumed to be covered as an occupational disease under Virginia Workers' Compensation Act when firefighters develops cancer. The bill also removes the compensability requirement that the employee who develops cancer had contact with a toxic substance encountered in the line of duty. And what this means, and you'll hear differently, what this means is that the firefighter would not have to specifically identify the exact carcinogen or toxic substance that caused their diagnosis of cancer on the exact day, on the exact fire. This is the main problem that we are having with the law at this time. It's time that we make this law a true cancer presumption law. Please support the legislation. Thank you.
Thank you very much, sir. Yes, sir.
Good morning. My name is Kurt Dietrich. I'm the president of the Portsmouth Professional Firefighters and Paramedics. We represent over 275 of the Portsmouth firefighters and paramedics. But we're also here today with the Virginia Professional Firefighters Association, which represents over 8,000 first responders in Virginia. And from what you saw earlier, whenever we started talking about this bill, all the firefighters that stood up, statistically, 25%, so 1 out of every 4 of us that stood up in this room will be diagnosed with occupational cancer. So all we're asking is that this bill be addressed and changed so that those firefighters can get the protections that they deserve. Thank you.
Thank you, Kurt. I appreciate it. Yes, sir.
Good afternoon, distinguished senators. Michael Riley, I'm the Executive Director of the Virginia Department of Fire Programs. Been a firefighter for over 40 years. Representing here, the governor wants to put forth his support for this bill.
Thank you.
Thank you, sir.
Are there any others that wish to speak? Yes, sir.
Good afternoon, Senators. Last year, Chief David Creasy stood before you, poured his heart and soul out on the cancer that he was battling. Unfortunately, in October, he lost his battle. I have a brother right now up in Philly at the Philadelphia Cancer Clinic. He's got terminal pancreatic cancer. He made a video the other day, spoke from his heart, and so I'm bringing his words to you today. We have to do something differently. Politicians love to shake hands and kiss babies. Do you know who you come in contact with on a daily basis? No, you don't. So when you get a cold and wonder where you caught your cold from, do you ever go back and talk to that person? It's the same thing with the smoke that we're absorbing and inhaling. They're full of carcinogens. We don't know where that smoke is, the breakdown of it, the chemical makeup of it, but we do know it's killing us. Please, please, please support this bill. It's well worth it. And for my brothers and sisters in this room, we're going to continue to fight however we have to do it until this is successful. Thank you very much for your time.
Thank you, sir. John?
All right, thank you, Mr. Chairman. We'll wrap it up very quickly. I do want to recognize one person who was too shy to speak. A good friend of mine, Levin Turner, who is an officer in the Portsmouth Fire Department. He's here as well. Mr. Chairman, you have several bills before you. I don't know if you want to do the rolling into one now and send them up to finance to make it less cumbersome for them, or whatever you think is best is what we'll do.
Yes, yes, yeah. Chrissy, which bills are identical to Senator Cosgrove's?
Senate Bill 1022, Senate Bill 1172, and Senate Bill 1528.
Okay.
Mr. Chairman, I'd move that we roll all of those into Senator Cosgrove's Bill 1030.
It's been moved and seconded that 1528, 1465, or 1172, I'm sorry, and 1022 be rolled into Senate Bill 1030. All those, the clerk open the rolls.
Senator Maduro, would you press me as an aye, please?
Okay.
Thank you. Thank you, Mr. Chairman.
12 ayes, 0 nays.
Okay, now that we rolled those bills together, is there a motion to report and re-refer these bills to Senate? Been moved and seconded that the 1030, which now contains 1022, 1172, and 1528, and Senate Bill 1465 be reported and re-referred to the Committee on Finance. Clerk, open the rolls. Okay.
13 ayes, 0 nays.
Okay. All righty, those bills are done. Okay. Moving on, who's next on the list here? Marsden, Chase. Senator Marsden.
Thank you, Mr. Chairman. Senate Bill 1017, we have a substitute.
Okay, there's a substitute before us. Been moved and seconded that the substitute 1017 be adopted. All those in favor, say aye. Okay, any nays? Okay, the substitute's before us.
Thank you, Mr. Chairman. This bill is a shadow of its former self. Initially, it had been a bill to raise the minimum wage over a 4-year period of time up to $11. My intent originally was to restore the buying power of the minimum wage to what it was in 1974, which was the last time it was generally considered to be doing what it was supposed to do. What this bill does before you today is raises the minimum wage to $8.50 per hour. That's it. That's as far as the bill goes. There are no out years. The current minimum wage is $7.25 per hour. That's only $15,000 a year for a full-time worker. These wage workers are important contributors to our economy. The average fast food minimum wage worker isn't a high school student anymore. He's 28 years old. People have to work 2 and 3 jobs simply to keep their heads above water. We have to get money in the hands of people who will spend it and put and spur economic activity. This is $50 more in a minimum wage worker's paycheck every week. These workers now have to depend on government support in order to supplement their low wages. I would rather see people paid for their labor than receive government subsidies. I think it's good for people's dignity. It's good for it's good public policy. In state after state, claims that minimum wage increases hurt workers are shown to be myths. It's just not true. Since 1938, federal minimum wage has been increased 22 times, and GDP growth has increased throughout these wage increases. One of the interesting things, there was a study done, and it turns out that the EITC, for instance, the increase in the refundability of the EITC has been the one thing that has worked in rural economies to spur economic growth. All of the things we come up with here in this body to create tax incentives in rural areas don't work as well as just putting money in the hands of people who will spend it. The one advantage to this plan, because it is only a 1-year increase, is that gives us time to evaluate any data on job growth, job loss, how it's impacted our economy, how it impacts people, and if there's any further increases in the out years that are considered, we'll have information to make that decision on, not just speculation as to what our theory is on what the minimum wage will do or not do. So that's the bill, Mr. Chairman, $8.50 per hour, go in effect next year. Thank you.
Hearing none, are there those in support of the bill? Yes, ma'am.
Hi, I'm Thomasine Wilson. I'm a home care worker, and I'm totally for this bill being passed, but I think it should be more than $8.20 or even $8. $7.25 is not going to make it. I've been doing home care for 20 years, and I think that the services that I provide, especially for people living longer, And I have a lot of clients who are in upper 90s into 100 years old, and the baby boomers are soon to be retiring and will be needing the service I provide. And I think that by home care workers not getting the services that, not being paid for the service that we're doing, if we get minimum wage increased to $15, it will make a major difference in the work that we do. We provide services for people with Alzheimer's and dementia. We're there to keep them from falling in their homes. We are certified in CPR and first aid in case an emergency arises while we are in the people's home. And a lot of times we're there for companions so they won't be home extended period of times alone and their family members can go to work. And I think it's not fair to us as workers who are licensed by the state. I have a CNA license. I pay for a PCA certification, and I'm not getting compensated for the hours that I put in. And even coming in here on a regular basis, putting my bid in for home care workers to get an increase, even when we get a 2% increase, the home care worker does not get it. The agency gets it. If it went up to $940, the agency got it. I still didn't get it. So I want the home care worker who's physically there doing the work, who are bathing, dressing, cleaning, cooking, providing services for your family members to be compensated for the time we put in. And the training that we get, you have to update your skills like every 30 days or so. So we're staying up to date with our skills. We're providing the service as people continue to age at home. They're not going to the nursing home. We're saving the state money every single year. I've been coming here since 2012 for the same issue, and this providing more money over a period of 5 years, a year. We should have that money now, this year, and during this session, because the bills are getting higher, the rents are not cheaper, your mortgage is not changing, and the money is not matching the work we do. And then people say work hard and longer. I'm working 10 hours, 5 days a week. We've been capped at 40. So even when the increase comes and I'm working longer hours, I don't get it on my pay. So I would like to have home care workers pay for the services we provide because we are saving the state money. And Medicaid expansion has come into place, and we are paid by Medicaid. So PCA is getting Medicaid money. There's more money in this pool to pay us this year, not next year, not 5 years from now. How many years do we need a study to get more money? If you go to the store, you see things cost more. You can't go to the store with $15,000, provide for a family with children, husband, wife, kids, even a single person. I can't manage by myself with the money that is being paid now. And I don't want to work 3 or 4 jobs. 8 hours as a female, go home to my family. Friday, get paid a decent income. So I would like for you to consider this year giving home care workers who make life easier for your grandmothers, grandfathers, mothers and fathers to stay at home so you can go to work, so we can give them that compassion care they need at home. And we can be looking forward to a payday that's a real check. So I'm for this bill, and I thank you for your time.
Thank you.
Good afternoon, Julia Newton, SEIU. We support this bill. Thank you.
Thank you so much.
Mr. Chairman, Committee, Warren Hoddle, Virginia Interfaith Center for Public Policy. Senators, there is a chasm that separates the rich and poor here in Virginia. That chasm divides and poisons our civic life. We call ourselves a commonwealth. That recognizes that we are mutually dependent in our pursuits. Our hope that this bill will help reduce the economic divisions among us.
Thank you.
Hi, Megan Healy, Chief Workforce Development Advisor. The administration supports this bill.
Thank you.
Hi, Laura Gorin, Research Director at the Commonwealth Institute for Fiscal Analysis. Virginia was recently ranked worst in the country as a place to work. That's in large part because our minimum wage is the lowest in the country compared to both the median wages that folks earn as well as the typical cost of living in the state. We have a number, 2/3 of poor families in the state have at least one working adult. Raising the minimum wage would help address these challenges. Thank you.
I'm Becca Saxon with the Virginia Education Association, and we support this bill.
Thank you.
Lana Heath Day Martinez with CASA Virginia, and we support this bill as it would help working families.
Thank you.
Thomas Bowman with the Mid-Atlantic Laborers Union. We support this bill as a step in the right direction.
Thank you. Okay.
Mr. Chairman.
Senator Stanley.
Mr. Chairman, and with no harm to the patron who I consider a friend, I'd ask that this bill go by temporarily. That'd be my motion.
And I see that we have another bill in conflict, Senator Marsden, so we'll take that bill up and then work out the differences and see how it goes, okay? All right, thank you. All right. Senator Peterson.
Thank you, Mr. Chair, members of the committee. This is Senate Bill 1115, and this bill will bring back a few memories, hopefully not the traumatic sort.
You'll be pleased to know on our docket it says Senator Chapman.
You know what? I'll go with that. That's
right,
fine. That's
all
what
right.
happens when you get a last name for a middle name.
All right.
Senate Bill 1115 actually is very similar to a bill I filed last year. It has to do with intervenor compensation. Intervenors are people that file essentially what would be a cause of action in front of the State Corporation Commission, challenging a rate that's been set either by a telephone company, a utility, any sort of public service corporation. And that's how a rate case, they do that as part of a rate case. And over the course of that, of course, there's no public defender for this case. There's no third-party funding. So if you have a large industrial concern like Newport News Shipping, that's not as big a concern, but where you have actual individual consumers and ratepayers, they can get stuck with what can be a fairly significant legal bill or expert fee bill. This actually came up. I know I had a constituent of Senator Sasslaw a couple years ago that had filed challenging the rate freeze bill, and her experience is actually what led me to bring this bill. We had this last year. I had a bunch of questions last year as to how we were going to fund this. I did not put in any money in the state budget, and I sort of covered that in lines 110 through 113. It just makes it apparent that the money would be covered from the SCC's own budget dealing with contingent expenses. They do carry that on their own book. So I know I had that question last year. So there's a lot of detail as to how you get covered, what is an intervenor, what would be the circumstances in which you could be reimbursed. It would be at the discretion of the commission. There's no right to it. But basically it would allow the SCC to reimburse intervenors in situations where it would be merited.
Thank you.
Yes, sir.
Are there questions for Senator Chapman? Peterson. Okay, are there those that wish to speak in favor of the bill? Are there those who are in opposition to the bill?
My nemesis.
Delegate Rust.
Mr. Chairman, John Rust on behalf of Dominion. This is a bill you've seen before. You saw it last year. Couple of comments. We have two taxpayer-funded entities that now represent the consumer at the commission. We have the staff of the commission. We also have the Attorney General Consumer Counsel that is there. There has been no showing of a hardship or problem from any intervener at this point that would justify the bill as we go through. Everybody has a right to appear. Everybody has a right to submit their comments as they go through. We simply don't think that the bill is necessary, and in any event, it would provide a very little relief to the intervener as they went through.
Okay. Are there questions? All right, we all heard the bill a year ago. We're all very familiar with it, so the committee operates by motion. I heard a motion to gently PBI.
Second.
It's been moved and seconded that the bill gently PPI. Clerk, open the roll.
Wait a minute, Mr. President.
Senator
Mr.
Norman.
Chair, I just want to say, in Senator Chapman knows this, the Senate is going to take votes on bills up or down. We're not going to just let them languish.
That's fine.
Okay. All right. Okay, the motion is to pass by indefinitely. Clerk, open the roll.
11 ayes, 3 nays.
Okay, that bill is passed by. Thank you, Senator Peterson. Next is, well, Senator McPike, we took care of. Senator Favola. You have.
Thank you, Mr. Chairman. This is Senate Bill 1059. It's on wage or salary history. And what my bill does is it prohibits an employer from asking about previous wage or salary history. And the reason I put this bill in is I believe that it levels the playing field. For prospective employees who may be reentering the workforce, who may have worked part-time, who, of course, moms who've been home taking care of children, those who have had a lower salary, oftentimes when they answer a question about salary history, shapes what their future employer will pay, whether that job should be tied to that payment or not. 47 or almost 48% of households in Virginia actually are headed by women with children under the age of 18. So they are the primary breadwinners. I believe that we should support policies and laws that promote equality and that really reinforce merit. And I believe that's what my bill does, and I respectfully ask for your vote of approval or voting aye.
Senator Norman has a question.
Senator Favola, does this pertain just to prospective women employees, or is it universally applicable?
Well, the law would take effect in
You
July
have
1st.
talked solely in gender terms. My question to you, is this gender neutral, and are you just using
It is
women
gender. It is
as an
gender neutral.
example?
It is gender
right.
gender
Second
neutral. I was
question.
speaking in terms of gender terms because I think women would benefit most from this bill, but the bill is gender neutral.
Senator Norman.
Second question, would this in any way constrain or prohibit an employer from asking a prospective employee, will you come to work and take this job for X dollars an hour?
No, it does not. It's a very narrow bill. It only discusses past wages, so it would not, my understanding is the example you just gave would not be affected by this bill.
Thank you.
Are there other questions for the patron?
Mr. Chairman.
Senator McDougal.
Senator, Favola, would this prevent an employer from looking at the database that has state employee wages on it to determining the wage?
No, it would not.
Mr.
And
Chairman.
that's public information, so it's not going to prevent an employer from looking at public
Mr. Chairman.
information.
Mr. Chairman.
Yes, Senator McDougal.
Doesn't the bill say attempt to obtain the wage or salary history? It doesn't say attempt to obtain it from a public source.
The intent was we couldn't prohibit public sources. I mean, if it's public, it's public. I can defer to General Counsel if you wish.
Well, Mr. Chairman, the language cited by the senator is correct, but then it continues from any current or former employer of the prospective employee in subsection B. So it's, I think the fact that they are prohibited from attempting to obtain information regarding the wage and salary history from a current or former employer would not apply to any other database where it might be available.
Mr. Chairman.
Senator McDougal.
So if the person is employed at a governmental entity and you look at that governmental entity's public database, are you not obtaining it from that current or former employer?
I don't intend to get into a running debate, but for example, the database of state employee salaries that I'm aware of is compiled pursuant to a FOIA request from the Richmond newspapers. So you'd be accessing the Richmond newspapers database. You wouldn't be asking the agency at which the person was employed, how much was this person making?
Mr. Chairman.
Senator McDougal.
But if, for example, a number of universities publish in their library the salaries of all their faculty and staff, and if you went and looked at that publicly available database in the library, you would be in violation of the statute.
That would be true.
The answer is yes. Isn't that correct?
Mr. Chairman, I'm not going to try to answer that,
Are
but
there
the
other
patron of the
questions?
bill may want to speak to it.
Are there other questions for the patron? Okay, are those that wish to speak in favor of the bill?
Good afternoon. Thank you for the opportunity to testify today. My name is Carol Stevens, and I am co-president of the AAUW of Virginia. American Association of University Women strongly supports Senate Bill 1059 and believes it signifies an important step toward closing the gender pay gap in Virginia. Senate Bill 1059 contains a crucial provision toward eliminating the gender pay gap, prohibiting the use of salary history in hiring decisions so past discrimination doesn't follow workers into future jobs. We've talked about what it does as far as affecting women more than men. However, this bill does apply to men as well. And an excellent candidate for a reliance on a salary history harms individuals who've taken away time from the workforce, also disproportionately impacts women. An excellent candidate for a position may have gained knowledge, skills, abilities through an unpaid internship or from volunteer work, or may have worked in a different geographic area where salaries were lower. Many times a worker has been laid off and needs to find a job, even if it is not at the same salary as the previously held job. Stating that higher salary, which is out of proportion to the job being sought, can work against that person as well. Most of these disadvantages to requiring salary history in the hiring process apply to men just as well as to women. Unfortunately, women are affected even more. It is only just that all start the application process on equal terms, which means eliminating the requirement of stating salary history. Virginia women have waited too long for equal pay. We can move one step closer if committee members pass Senate Bill 1059 today. Thank you.
Thank you. Senator Favola, I just have one question, having hired a lot of folks. When I'm working alongside another company and I see a welder I like, and he works for the other company, would I be in violation? I said, how much you making? And he tells me 24 an hour, and I said, I'll give you 26 an hour, come to work for me. I mean, I just asked him how much he was making. I want him, and I'm gonna pay him more. Would that be in violation?
Again, I think that's voluntary. It says no employer shall require as a condition of employment. So,
It says attempting to obtain wage or salary history. And that was certainly an attempt to find out how much more I'd have
but
to
you would
pay
be
him now.
asking has a
Prospective employer.
prospective employer. Again, you're taking very literal interpretations of this. That would not be my expectation. I mean, the intent of this bill, and maybe I should have drafted it more narrowly, was when an employee is sitting before an employer, the information is not public, and the employer is asking the employee for wage history where the employee would not be voluntarily inclined to provide it. This would be sort of leveling the playing field. We don't want wage history to be a condition of an employer making a decision necessarily.
Okay, thank you. Are there those that wish to speak against the bill?
Good afternoon, Mr. Chairman. Nicole Rowley with NFIB, representing Virginia small business owners. We're in opposition to the bill. We support the rights of our small business owners to be able to make inquiries. For many of them, they do not have human resources departments, so keep in mind they wouldn't necessarily have the capability or the means to be able to do some type of big studies into what the market bears and various positions. And so these are ways for them to be able to know what is out there in the market and to be able, we certainly wouldn't want our small business owners to be in a position where they're lowballing prospective employees. In fact, right now, many of our small business owners say that they cannot find good qualified workers. And so it's a very competitive market right now. Tight market labor market, and so this is just a means for them to be able to know what is going to be good pay for them to attract good employees. Thank you.
Senator Sasslaw.
Mr. Chairman, members of the committee, Kate Baker on behalf of the Virginia Retail Federation, we also oppose this bill.
Thank you.
Mr. Chairman, Keith Martin with Virginia Chamber of Commerce. While we appreciate the senator's efforts in regards to pay equity, we think this bill is too limiting. There are many times where both the employer and employees need to know this information for negotiation purposes, particularly when you're talking about sales commissions, bonuses, and other types of benefits. For those reasons, we oppose the bill.
Okay, thank you. All right, we heard from both sides. Senator Favola, anything you'd like to say?
I think you've heard a good summary of the bill and its intent.
Okay. All right, thank you. All right, committee operates by motion, and Senator Norman promised we'd have a motion. Been moved and seconded that Senate Bill 1059 be reported. Clerk, open the roll.
Five ayes, 9 nays.
Okay.
Thank you.
Thank you. Senator Howe, you've been waiting patiently. Sort of.
Thank you, Mr. Chairman. Before I begin, I have a question about my Senate Bill 1112. That's the Student Loan Servicers Bill. In the past, that's been heard in Ed Health, but I didn't hear you referring
I think it's because it didn't get to the docket fast enough. It's not on the docket now, but we'll refer it next Monday, unless it needs to be there any quicker. You still have time?
Yeah, I would send it.
Right now?
Yeah.
Okay, no, it's not on the docket. We'll call up Senate Bill 1112 of committee. I'd look for a motion to re-refer that to Committee on Health and Ed.
Second.
Been moved and seconded that bill be referred to Committee on Health and Ed. All those in favor, clerk, open the roll. There you go, Senator Howe. Got
Great.
one.
I got one.
One.
Good. Thank
All right.
you.
14 ayes,
Thank
0
you. You know, I only come to this committee about once a decade, so, you know.
Okay, Senator.
Okay, I've got Senate Bill 1103. This bill removes the exemption from the Virginia Minimum Wage Act of any person who normally works and is paid on the basis of the amount of work done, that is by the piece. It usually applies to textile workers and people who are doing clothing. Strangely, this is covered in the Federal Minimum Wage Act. They are covered under the federal, but not in the Virginia. And in looking it over, I think it's just been an oversight over the years. But it's a pretty important oversight. And in fact, only Virginia and New Mexico are the only ones that don't include piece workers in the minimum wage. For me, this is actually very personal. It's a legacy thing. My mother was an organizer of piece workers before I was born. And over the table, the dining room table, I would hear about how poorly they were treated and how unscrupulous employers would undercount their work and by other skullduggery deprive them of their rightful wages. What this does is just gives them the security that they will be covered by the minimum wage, and it helps the honest employer by protecting him from those that might not be so scrupulous.
Okay, are there questions for the patron? Senator Howell, do you have ready to speak in favor of the bill? Hello, Kim.
Hey, Kim Bobo, Virginia Interfaith Center. We support this bill. It's a minor cleanup of the law. It doesn't mean that you can't still pay by the piece. It just means when you pay by the piece, you also have to make sure people are paid the minimum wage. So thank you.
Thank you.
Hello, Julia Newton, SCIU. We support this bill.
Thank you.
Good afternoon, Megan Healy, Chief Workforce Development Officer for the Governor. We support this bill.
Thank you. Are there those opposed to the bill?
Mr. Chairman, members of the committee, Nicole Riley with N5B. As we stated before with the previous bill, our main concern and only concern with this bill is that it is tied to the Virginia Minimum Wage Act. Thank you.
Thank you.
Mr. Chairman, I'd like to assure everybody that should anybody try to amend this bill by making it broader for the minimum wage, I'll stand up and oppose that.
Thank
and
you.
vote against that.
Thank you.
Mr. Chairman, members of the committee, Jody Roth on behalf of Virginia Retail Federation, and we oppose this bill for the same reasons we oppose the other bill, because it is tied to the Minimum Wage Act, and we view it as a vehicle. Thank you.
Thank you. Okay.
Mr. Chairman, members of the committee, Robert Melvin with the Virginia Restaurant Lodging and Travel Association. For the same reasons that have been previously mentioned, we are opposed to this bill.
Thank you. Thank you. All right, we've heard from both sides, and we reported out one bill like this already.
Mr. Chairman?
Senator, did you have a comment? Okay, it's been moved and seconded that the bill be reported, Senate Bill 1103. Clerk, open the rolls. Yeah.
Six ayes, 7 nays.
Okay, thank you, Senator Howe. All right, Senator Dance, I believe you have a minimum wage bill. We've cleared everything from non-committee members.
Okay, Mr. Chairman, this is another minimum wage bill, and I know they've been waiting for this one. And my bill is differs from Senator Marsden's in that his stops at $8.25. Mine starts at $10 per hour, and it's a progressive bill. The first year, July 1, 2019, it would raise the minimum wage from $7.25 to $10 per hour, effective July 1, 2019. Effective July 1, 20, it would go to $13 an hour, and on July 1, 2021, it would rise to $15 per hour. This is a progressive, really 15-hour minimum wage bill. But it also provides, I'll wait for you. I have to wait for them, Mr. Chair. No, they're not listening. I'm waiting for them.
Wait,
Okay.
we're listening.
I
We're
know they
listening.
don't want to miss this. There is a proviso here that the minimum wage as presented would be required by the federal, as is required by the Federal Fair Labor Standards Act, would be adjusted therein. The measure provides that the Virginia minimum wage applies to persons whose employment is covered by the Fair Labor Standards Act. So it only refers to those that fall within those guidelines.
Okay. We're still listening. I am.
You're still listening?
Yeah, I'm still listening.
Okay. I am asking that I could go further, but on those premises.
I think we understand the provisions. Are there questions for the patron? Seeing none, I assume the same speakers are going to speak on both sides. Would that be a fair assumption? We've heard from both sides continuously. I'm seeing nods. SEIU, same. Got it. Okay. Governor's office position. Same position in favor. Okay. All right. We've heard from both sides. We've taken the testimony. Senator Norman.
I move to report.
It's been moved and seconded that the bill be reported. Clerk, open the rolls. Close the roll.
Be still my heart.
6 ayes, 4 nays.
That bill's reported, Senator Dance.
Thank you.
You are certainly welcome. Surprises happen even on a Monday. Okay, Senator Mason's not here yet, so I do have a bill. I do have a bill to be heard here. Yeah.
Mr. Chair, Mr. Chair, Mr. Chair, Mr. Chair, I forgot I have a second bill.
You're pushing your luck, but okay. Is it on the docket?
It is on the docket.
It is on the docket. Senate Bill 1200. Oh, no, Senate Bill 1188.
Thank you. Mr. Chairman, this is an amended language before you. So it's amendment in nature of a substitute that should be before you, or is being.
Is there a motion on the substitute?
Yes.
Been moved and seconded that the substitute be agreed to. All those in favor say aye. Aye. Any opposed? Okay, the substitute's before. Senator Dance.
Thank you. The amended language before you conforms Senate Bill 1188 to the House iteration of the bill, House Bill 2038, as carried by Delegate Ransom. The bill makes changes to Virginia's Extended Services Contract Act, specifically to remove an unnecessary mandatory bond requirement, which is costly for business, and gives VDOT stronger consumer protections in order to enforce the act. This act regulates certain warranties and protection products such as tire and wheel protection, paintless dent repair, windshield repair, key replacement, and theft protection products. The reason for the legislation is to bring Virginia's laws in line with the other 49 states and follow a national trend to remove unnecessary bonds. I know of no opposition to this great piece of legislation, and it meets the standards of the National Association of Insurance Commissioners as well as the Motor Vehicle Products Protection Association.
All right, you don't want us to march to the tune of our own drummer. You'd like us to in step. Is there any opposition to the bill? Seeing none, the committee operates by motion.
Mr. Chairman, can I ask a question?
Certainly.
Maybe VDAX is here? Now, my understanding is what we want to do is make sure that consumers who buy this coverage actually get the benefit of the coverage. And right now, we've got two ways of guaranteeing that, I understand. One is the general liability policy, and one is bonding those obligations, right?
Mr. Chairman, the bond is applied to all the obligors. So if that can be the original manufacturer that's covering it, as well as a third-party obligor, but all obligors have a bond right now, and then
and this would jettison the bond requirement.
That jettisons the bond.
So if an obligor under one of these plans has a general liability policy, what I want to know is if they default, which is the reason for this protection, if they're not providing the benefit to the consumer, to me, I've got a ding in my truck, and the obligor, has defaulted, doesn't honor the obligation to fix it. If they've defaulted on that, chances are they've defaulted also on their general liability coverage. If that coverage has been canceled for non-payment, and say I bought my truck 6 months ago, a week ago they defaulted and the coverage was terminated, and a week from now I get my ding, is the general liability coverage that's been canceled going to repair my ding?
Under present law, the third-party obligor, which are those that are administrating the obligations of the obligor instead of the actual original manufacturer. So they essentially allow a third party to obligate that. Under that scenario, the third party obligor only has the CLIP, the casualty liability insurance policy. But if the manufacturer is administrating their obligations directly, then they're not going to have a CLIP. So just to,
well, how about a company that has a CLIP?
Okay.
And that policy is canceled for non-payment.
Mm-hmm.
Is that policy going to provide those benefits if my vehicle's damaged a week from now?
If the clip has been canceled, then obviously under the existing bill, the way we're reading it, is and then they're gonna have to take essentially, then it's gonna fall onto the obligor to essentially
So
fulfill.
you're satisfied that somebody is going to fix my car if I've paid that for that coverage?
In the cases, if both the obligor and the clip, if the
Clip's
obligor
been
bankrupts,
terminated for non-payment.
in that case, I don't think that's,
A bond would ensure that there's money
Correct.
there to make sure my car is fixed, right?
but if there's bankruptcy proceedings in place, which is what you're getting at, Senator, correct?
Potentially.
Then I don't think necessarily this bill will address that.
The bond would survive bankruptcy.
Correct, it would, but not
Okay.
the clip.
But neither the clip nor the obligation of the obligor.
Correct.
So it may be, by doing away with this, it may be consumers are left high and dry?
You could drive that, Senator.
Mr. Chairman?
Yes.
Mr. Skiles may have a different view.
Slightly. Mr. Chairman, Senator Rubenstein, David Skiles with the Vector Corporation representing the Motor Vehicle Products Protection Association. To take a step back, Senator Rubenstein, as Michael from VDAX mentioned, you have two options under existing law. The company can maintain the CLIP, commercial liability policy, or they can file audited financial returns showing a net worth in excess of $100 million. That's existing law. In addition to that, they are also required to file a mandatory bond. I will point out, just as background, no other state in the nation requires that mandatory bond. I understand we do things slightly different here in Virginia, and I respect that. To your point, if the company were to default and the commercial liability insurance policy were to default, which I would submit is probably an unlikely scenario, then I guess there would be a potential gap, for lack of a better term. But I think it's important to note that if the obligor or the insurance company cancels the CLIP, by existing code, Title 38.2, there has to be a certain period of notice, and any policies that are insured up until the point in which termination is made effective would be guaranteed under the CLIP. So I hope that answers your question. I think when you look nationwide and you look at the Model Services Contract Act that had been put out by the National Association of Insurance Commissioners, as I mentioned, there is no state that requires a mandatory bond. The bill that Senator Dance has brought forward complies with NAICS Model Extended Services Contract Act. And obviously, we haven't seen these types of situations arise in other states.
Okay, Senator Rubenstein, you satisfied?
I'm hearing.
I'm hearing. All right. Is there anyone opposed to this legislation? I asked that earlier. No one's stood up. Okay, committee operates by motion. Been moved and seconded that the amendment in nature substitute be reported. All those in favor? Committee clerk, open the roll. Oh, sorry. How do I do that?
No, I'm just.
All right. Close the roll.
12 ayes, 0 nays, 1 abstention.
Okay. Bill's reported.
Thank
Two
you.
for two. Senator Mason.
Yes, sir. Thank you, Mr. Chairman. Senate Bill 1411, Mr. Chairman, I'm
like
not sure how it found a home here, but from contracts and bonding to burn buildings, the National Fire Protection Association do a lot of training. Men and women in the fire departments do a lot of training to be prepared for the real scene. The code refers to these structures that they train in as burn buildings. The National Fire Protection Association calls them live fire training structures. So we're proposing to, instead of calling them a burn building, call it a live fire training structure on line 86, Mr. Chairman.
Senator Mason, we are a multifunctional committee here, and it sounds like a good bill. Is there anyone opposed to this legislation? Committee operates by motion. Been moved and seconded that Senate Bill 1411 be reported. All those in favor say, oh, clerk, open a roll.
13 yeas, 0 nays.
Thank you, Mr.
Now
Chairman,
get to
and most of
explain
the
it.
members of the committee.
You get to explain that. All right, I do have the last bill on the docket, so I'm going to take the floor. Senator Newman, if you would chair the committee, I would appreciate it. I do want to.
Committee will turn their attention to Senate Bill 1393.
Thank you, Mr. Chairman. And what Senate Bill 13987 comes to you?
Well, Senator Wagner, you have three bills, okay,
1387.
1387.
The other two have been taken care of, Mr. Chairman. 1387 comes to you. I had the opportunity to, and this is scary, but teach a course at Christopher Newport University this past session. Got a chance to meet with a lot of the professors there, and one of the professors brought to my attention things that have gone on with students there at CNU who want internships so badly, and they end up willing to sign anything to get an internship, and in the process of doing that, they basically sign non-compete agreements, which several employers have been forced upon them and really limited their ability to get jobs upon graduation. So this bill doesn't do away with non-competes. It simply sets a parameter for low-wage folks who may get caught in this inadvertently in desperation to get a job. And with earnings less than the average weekly wage of the Commonwealth, it's what the definition of low wage is, in case there's a concern about that. And I've asked a professor from CNU who's done far more extensive research on this, Mr. Chairman, to come and present what she found out in the course of doing this research. There is an amendment, and I would ask the clerk if you could read that amendment. I'd appreciate it. Let's get it in the right form.
Thank you, Mr. Chairman. On line 27, after experience, insert low-wage employee also includes an individual who is independently contracted with another person to perform services independent of an employment relationship and who is compensated for such services by such person at an hourly rate that is less than the median hourly wage for the Commonwealth for all occupations as reported for the preceding year by the Bureau of Labor Statistics of the U.S. Department of Labor.
All right, we heard the amendment. Is there a motion on the amendment? So motion is second that the amendment be agreed to. All in favor will say aye. Those no, amendment's agreed to. All those that are in favor of the bill, if you'd come forward.
Linda, go ahead.
Thank you. Thank you, Senator Wagner.
Mr. Chairman, Linda's going to give you a little bit more extensive than just saying she's in favor of the bill.
Okay.
She's done a
She's
lot of
in
research.
favor as well, right?
Yes, I would imagine.
The impetus of this bill was one of my students last spring. I'm a law professor at Christopher Newport University. I teach business law. This is my 13th year teaching. I've been an attorney for 21 years. I was not aware that this type of situation occurred in this country until a student asked me to look over her internship agreement. I asked her to send it to me, and it was 9 pages long. Her internship was for 3 months in the summer last year. At first, I thought that this had to be a mistake, that they had given my student the packet that they would normally give to a full-time employee. But by reading through the contract, I realized they had specifically been changed to address the fact that she was only working for them for 3 months. So she has a 3-month internship. She has a 3-month non-compete. So I wondered, is this an outlier or what's going on? And so I embarked on a research last summer, and I'm in the process of finishing a research paper on this topic. This is a problem. Low-wage earners are being held captive, you might say, by employers because they have these non-competes. The research suggests that they don't understand what these non-competes mean, that they sign these non-competes without this understanding, and that they have no ability to fight the non-compete. Non-competes typically protect an employer's protectable business interests, but what's happening here is that these workers don't truly have a protected interest. And so they are told that they cannot leave this company for another job, which can suppress their wages arbitrarily. And the fear of the litigation itself will often keep them from looking into other opportunities. Attorneys have suggested to me that the cost to defend or fight one of these cases is $20,000 to $30,000. So they don't have the money to fight the non-compete. Many of these non-competes would not be upheld if they were able to fight them. This bill has three very important provisions. Number one, it gives the worker access to the courts because it allows them attorney's fees and costs. So now attorneys will be willing to take their cases. They will be able to go to court to get these provisions overturned if an employer seeks to hold them to that. In addition, to prevent employers from continuing to write non-competes that are not appropriate, there is a hefty fine. And very importantly, this bill has a notice requirement. Since many employees do not understand the law and they don't know the meaning of this language in their contract, and many just sign it and don't actually negotiate these, this has an affirmative duty that employers must have notice in their employment facility where it tells employees that these types of agreements would be void or not enforceable. I ask that you support this bill.
All right, Senator Wagner, other here to speak in favor of the bill?
No, Mr. Chairman.
Okay.
There's a few oppositions, I think.
All right, all those that have some concerns about the bill?
Mr. Chairman, members of the committee, Nicole Riley with NFIB. We have always supported the rights of our business owners to be able to use and utilize non-competes in very limited certain instances. And those typically deal with what the courts have said are appropriate areas such as trade secrets, client lists for some of our members. I'm assuming some of these things could be those areas where there are, like I said, particularly client lists for many of our small business owners. So for that reason, we would be opposed to the bill.
Thank you. Others in opposition? Senator Wagner, you want to wrap up?
Yeah, Mr. Chairman, I just want to say that this is not geared, and I've been subject to non-competes and willingly signed them knowing what I was, getting into. This deals with interns, people of little skill, little understanding, and by their own definition, making significantly below the average wages of Virginians. And so that's what the bill does, and hope you would support it.
Great. Senator Oberchain.
Yeah, I just want to say I agree with Professor, with Senator Wagner, that there are many instances in which a covenant not to compete is a bad idea, which it's illegal, shouldn't be allowed. And fortunately, the Virginia Supreme Court has taken a very restrictive view of covenants not to compete and their enforceability. It construes most of them, many of them, particularly in the instances you've described, as being unenforceable. What concerns me is the broad brush that's being applied. I can imagine that there are circumstances in which one would be valid. Narrowly construed, a person who is engaged in sales for a specific product in a specific market. It may not generate a lot of income, but there may just be two purveyors of that product. And it might be very reasonable to say you can't go work for my competitor and take that knowledge or the customers that you have relationships with and go work for that customer. Covenant not to compete for that situation would and probably should be upheld as long as it's geographically narrow and narrowly tailored. I think the intentions are good. I think that there are situations where a covenant not to compete ought to be enforceable in those limited circumstances. So I just would hope that we would not report this well-intentioned bill.
Mr. Chairman.
Senator Stanley.
Only to kind of take the opposite view, because I see this probably in practice. I get many phone calls from those people who are in low-wage positions and have signed these non-competes. And it's nice to sit up here as we do as lawyers who have experience in these things and say, well, in Virginia, we have it limited in scope and duration, so it's great. But what we forget is that low-wage employee has to go hire that high-priced, powerful attorney and go sue to get out of that non-compete and use that limited in scope and in usually it's distance around the home office of wherever they're working. What you're trying to do, if I'm to understand correctly, and if so, I don't know why this is a problem if we limit it in duration and scope and distance. Why is someone who is at a lower wage even subject to these things? I understand there may be those rare occasions, but I think what you're trying to accomplish here, Senator Wagner, is a good thing. And I think we should acknowledge not only that you actually have a good bill, but that I think it serves a good purpose as well. So thank you, Mr. Chairman.
I've looked at the docket,
Chairman.
Senator Stanley. I appreciate the comment.
Move the report.
Senator Sproul.
Move the report.
Motion second to report. Senator Wagner, just briefly, I appreciate the bill and support it, but I do think Virginia's got to take a quick look and maybe even a long look at non-competes. We all talk about how limited Virginia is, but the fact is there was cases just recently out of Roanoke that were not narrow, in my opinion, at all, and they have been supported. So I appreciate what you're doing, but I think that a broader look at the appropriate time may be helpful as well. If there's nothing else, there's a motion and second. All those in favor record your votes aye. Those opposed, no. And the clerk will close the roll.
11 ayes, 1 nay, 1 abstention.
11 ayes, 1 nay, 1 abstention. The bill passes. Thank you, Mr.
Thank you,
Chairman.
Mr. Chairman. And I believe, as chairman, that completes the docket, so the committee shall rise.